100 தானே?
100க்கு மேல
அதுல போட்டோ வைக்கிறது எப்படி மேடம்?
Good morning.
Good morning to all participants. Resource person has been arrived. Shall we start the session, ma'am? Suganya, ma'am?
Yes, ma'am, we can.
Oh, okay, ma'am. Okay.
Uh, Let me share my screen first.
Good morning to all. At the outset, I wish to thank everyone present here for joining us for the national level workshop on an overview of patents and procedure for protection, organized by Department of Civil Engineering in association with Institution Innovation Council. Let me begin by thanking our institution for their untiring efforts and supporting making this event a reality. At this moment, I am really privileged to welcome Mrs. Suganya Jevelu, patent analyst, Putran and Associate Chennai, to this workshop. I am most delighted that she has been able to accommodate this event over online platform in her very busy schedule of activities. Welcome, ma'am. On behalf of the institution, I extend my heartiest welcome to all the participants present here for today's workshop. Now I call upon Mrs. Lima ma'am, Assistant Professor in Department of Civil Engineering, to introduce about the resource person.
Good morning to one and all present here. Let me take this occasion to introduce our resource person, Mrs. Suganya Jayvelu. Mrs. Suganya Jayvelu is currently working as a patent analyst at Putran and Associate Chennai. She completed her bachelor's degree in computer science and master's degree in information technology. She has a total experience in the field of patent of around 12 years. Out of 12 years, 5 years of experience in intellectual property in all forms of IP, 3 years of experience in research and development in IP department, and 4 years of experience in patents for both national and international. She also acted as a certified patent agent since 2018 onwards. She has a vast professional experience in the field of IP. And around 2010 to 15, she worked as an operation assistant in Rights and Marks, an international law firm. At that time, she has a specialization in trademark, copyright, design and patent, prosecution and management for both national and international. From 2016 to 18, she worked as an admin in IP research and development of Saint Gobain Glass, Chennai. She has a specialized in patent prosecution, portfolio management, ideation and brainstorming sessions with inventors and other IP management. And also, she worked as a part of information research management team. And from 2019 to till date, she now working as a patent analyst in Putran and Associates, intellectual property attorney, Chennai, and has a specialization in patent searches, FTO analysis, filing and prosecution of Indian patent, conventional PCT and national phase cases, IPR due diligence, and portfolio management and managing patent team. And now I formally hand over the session to Mrs. Suganya Jevelu. The screen is over to you, ma'am. Please, ma'am.
Thank you, ma'am. Thank you for your warm welcome. Good morning, all. It's my pleasure to have you all here for the session on an overview on patents and procedure for protection. So today we are going to see about patent, what it is, and what are the patentability criteria, what is patent search, what are the filing procedure, what is granted patents, and some notes about international filings. So let's go ahead. So what is patent? So patent is like now it's everyone is aware of patents. Earlier it was not that much awareness about the patents to the general public. Now everyone is aware of patents and what is innovations and how to protect this and what all the benefits available from the patent office. All those things are readily available to the general public, institutions and others. Even students are nowadays filing patents in general.
Excuse me, ma'am.
So,
Ma'am, sorry for interruption. Can you make your screen to the full screen mode, ma'am?
yes, I did. Once again. Is it visible now?
Not yet, ma'am.
No. Okay, let me see. Is it visible now?
Yes, ma'am. It's still in the present. It's not in the full screen mode.
Oh, okay. One second. But for me, it looks full screen now. So you could able to see the PPT, but not in the presentation
Yes,
mode.
ma'am. Yes, ma'am.
Now we could. Is it fine now? You could able to see. Oh,
Not yet, ma'am. Share your entire screen, ma'am.
I hope now it will be visible. Now.
Yes, ma'am. Yes, yes. Yes, ma'am.
Okay.
Thank you. Thank you.
Okay, thank you. So like I'm explaining about patents, no? So what is patents? So patent is one of the intellectual property rights related to the inventions. So what all the invention having technical ability, which will be granted as a patent. So grant of patent, it's for a particular period of time. The term of the patent is 20 years from the date of filing. So what is the purpose of patenting? So it will exclude others from making, using, or selling or importing the patented product or the process. So you can avoid infringement if you have the patent protection. And the patent rights are territorial. For example, if you are filing the patent application in India, your rights are only applicable with respect to India. If you would like to extend your rights, or if you would like to get protection in other countries, you have to file for an application individually in respective countries. The patent system in India is governed by the Patents Act 1970 and the Patents Rule 2003. There are a couple of amendments after 2003, and the recent amendment was last October with regard to fees to the institutions and other small and startups. So patent offices are located in Calcutta, Bombay, Delhi, and Chennai. The application should be filed based on the jurisdiction of the applicant. So respectively, the patent offices will be allocated with respect to the location of the application. That's why they have segregated major 4 cities. Who can apply patent? The true and first inventor. Like if you're the true inventor and if you have the co-inventor, and you can either alone or jointly can file the patent application. So any assignee of the inventor, for example, if you're working in a company and you are the inventor, you are creating your invention using the products or the materials of the company, then the assignee would be the company. So that company can file a patent and you can be listed as an inventor. Any legal representative of the deceased inventor or his assignee can also file the patent applications. What is patentable invention? For filing the patent application, there are 3 major criteria. These 3 criteria are almost applicable in all over the countries. The first one is novelty. So novelty in the sense your invention should be novel and it should not be published anywhere in the world, like in any form, like paper publication, journal publication, or a product launch. Nowhere it should be available before the date of patent filing. So novelty is the major criteria. So in most of the times, students or the professor used to publish the papers and then they will go for patent filing. Generally, that is not acceptable or allowed. So you have to first file your patent application and then you can go for a publication. The second one is inventive step. Inventive step in the sense there should be some technical advancement over the existing product or a process. Your invention should be kind of problem solution approach. So if there is already a product and you are finding some invention related to that product, what is the technical advancement? What is the technical effect over the existing? Then only the inventiveness can be accurate. So generally it will be said like it should not obvious to the person skilled in the art. So the person in the same technology should not feel this is very common. So you have to be like your invention should have technical advancement. That is what's meant by inventive step. And industrial applicability. So industrial applicability, it's also one of the important factor that your invention should work in an industry. So for example, if you are creating some product and which is something not at all workable, then there is no use for that particular invention. So that this criteria has came up. So whatever is invented by you, it should be like, it can be a prototype at the beginning level, but on the go you have to make it as a product, and it should work in an industry, and it should be useful for the general public. So these are the major criteria you have to see before applying for the patent application. Like there are certain clauses, certain inventions are not patentable as per section 3 of the Indian Patent Act. So here I have listed some of the first one is frivolous or contrary to natural laws. For example, if something is not imaginable, so for example, if you are saying a machine can give 100% efficacy, so you cannot like it can work efficiently and can provide 100% result, you cannot tell that. So that is something not patentable. And the second one is contrary to public order or morality, or cause damage to health or any living being. For example, if you are preparing some device or something which will harmful to the public, that cannot be patentable. Other thing is discovery of scientific principle or abstract theory of living being. Like if you are discovering any material or any substance which is freely available in the nature, that is not patentable as per section 3C of the Indian Patent Act. For example, you cannot take some microorganism which is already available in the nature, and you cannot claim this is your invention. That is kind of discovery. And a new form of known substance. A known substance, this clause mainly for the chemical related inventions. For example, if you are combining two substances and there is no synergy, there is no efficacy, then you cannot claim this is as a new invention. So that will be objected under section 3 of the Indian Patent Act. The other one is mere arrangement or rearrangement. So as a word says rearrangement, so you cannot arrange things one by one. Like there are the things can work separately, and you are just arranging and saying it is new. So that cannot be patentable. Invention related to agriculture or horticulture, generally a method of producing a plant or method of cultivation is not patentable as per Indian Patent Act. And some of the inventions, those are related to treatment of curing a disease. For example, if you are telling the method, if you do like this, it can be curable. So those kind of methods, like medicinal methods, surgical methods, cannot be patentable as per section 3I of the Indian Patent Act. Plants and animals. Plants cannot be patentable as a whole or in a pot. So there is one section called plant varieties. So those things can be registered under plant varieties if there is any invention related to plant growth and something. And the other thing is software and business methods. Software, in the sense, the codings, the algorithms, whatever you are returning to make a system or an apparatus or a device to work, like you are giving some codings or writing some scripts, those things cannot be patentable. Those can be filed under Copyright Act as a literary work. Also, the business methods. If you're explaining some of the business methods, those you can say it's my new method, but that cannot be patentable. Also, method of calculation, formulation, equations, those things cannot be patentable as per section 3K of Indian Patent Act. This is something very common section, like objected by the patent office with regards to software and teaching methods. Any method of performing a mental act or a method of playing games. So, for example, playing chess or any other games cannot be patentable because you are applying your mental act. There is nothing inventive there. Presentation of information. If you are presenting some slides like the way I am doing. You cannot claim it is kind of invention because you're just presenting something. And traditional knowledge, for example, turmeric and other traditionally known biorelated materials. There is no other addition to that. You're just taking the material and claiming this is your invention, that cannot be patentable. But some extract or other improvement over that can be considered as a patentable subject matter. The other section under which the invention cannot be patentable is section 4. That means for the invention relating to atomic energy, like some invention related to defense purpose, something related to other which spoil the health of the or health and wealth of the country, that cannot be patentable under section 4 of the Indian Patent Act. So there are some general precautions for the applicant before they are going to file patent application. Okay, they should not publish the invention anywhere in the public domain. As I mentioned earlier, any form like even publishing their product details in the website also can be considered as prior publication. So it is not advisable to publish anything before the patent filing. But somehow if the manufacturing or other science or research related people, they always tend to do some trials. Those kind of secret working of invention or reasonable trials can be acceptable before patent filing. But it should not be disclosed to anyone. Also, it is advisable to conduct the patent search before the patent filing. We have to file the application first to claim the priority. Then only the date on which the patent application will be filed is your priority date, and your rights will start from the priority date. So it is very important to obtain the priority date before you are doing any act with respect to your business or publishing your papers or whatever. So it is not required. You have to wait until your invention is complete, like to get a proper shape or to be completed and can be worked. If you think, if you have an invention which can be workable and you have some details about that invention, like concept ideas, then you can go for the provisional filing just to get the priority date and just to protect the concept of your particular process or a product. Then you can go with the completed patent after some time as prescribed by the patent office. There are some general information for the inventors as well. Generally the inventors used to do a lot of research and they used to be in lab and do a couple of works, but generally they don't record anything. And once they are not available or if they would like to prove something, they don't have any proof whatever they have performed in the lab. So it is necessary to maintain the records of research work, whatever they are doing, like a research note or a documentary or any form. They can record their research work which can be useful while filing the patent application. As I said, it is not advisable to publish your invention before the filing. You can file the application as early as possible before the publication. So for patent drafting, you have to select the you have to obtain one patent attorney, or else you can draft the specification by yourself. But you have to take care of the clients before filing the patent application. That means complete patent application. So once the patent is filed, there are a lot of process involving in the patent registration. So most of them things like once it is filed and they can get the publication or application number, that's it. The patent is over. But that is not the case. So after the application, once it is published, there is examination and then it will go for grant. And even after grant also, you have to maintain your application. That means if you would like your patent to be alive, then you have to keep your you have to pay the annuity fees yearly till the end of 20 years to keep your patent alive. Now the next topic is patent search. Okay, what is patent searching? So like, okay, this is my invention. So if I want to do the search, I can do the search based on my invention. Whatever the details available with me, I can do the search. But you have to do the comprehensive search before proceeding with the patent application. So what will you search? We are searching basically to find out the prior art. That's what I said like earlier. You cannot file a patent application without checking the details of the existing, whatever is already available in the public domain. So you can always do the prior art search. That means prior plus art, as I stated, existing knowledge. The knowledge can be in the form of patent, in the form of journal, or in the form of video, or some product or a process, whatever it is. But you have to do the search to check whether something is already available. What if something is already available, but unknowingly you are also filed the patent? Then there will be some conflict, and there will be some infringement, or the other person can be a major company. They can always file a suit against you. So it is better to file a do the prior art search before filing the patent application. So also, why the prior art search is required? Because I know my invention is very new, so I don't want to do any search to like make sure this is new and all. So most of the inventors are like that, but that is not the case, because it will help you to check patentability. As I stated in my earlier slide, so novelty, inventiveness is the major aspects. Okay, so to assess the novelty and inventiveness, you have to do the patentability check before filing the patent application. It will also help you to identify closest prior art. For example, if there is a very relevant close prior art, there is minute different, but then you can rework on your research, and what can be done to make this invention technically advanced. In that aspect, you can do the further research on your invention, and then you can go with the patent filing. It also helps filing a stronger application, because if you know there is a prior art, then you are doing further research, then that thing may not be available, so your application will be stronger, and it also meets the novelty and inventiveness criteria. It also check infringements, whether you are infringing somebody's patent, product, or a process. To check that also, it will help. The prior art search will help. That's why it is advisable to do the prior art search before patent filing. This search also will help you to identify competitors. If you are a manufacturing company of some automobiles, and if you'd like to see what are the patents filed by my competitors, you can also do the search to find out. So all these options are available for doing the patent search. So patent search is important, but how will you do the patent search? There are two options, only two things are required. One is the computer and the search engine or the database. So there are freely available databases available free. You can do the patent search by yourself. Also, there are databases you have to pay and get it. In that, you can do the patent search, and you can also do the search in the databases of the major patent offices like EPO, USPTO, WIPO. World Intellectual Property Organization is the major patent database known to check patents known to check for international patents. Whatever filed globally, you can have a check here. You can also do the check in Indian Patent Office, that is called INPAS. So these are the databases available for doing the patent search. There are a couple of other searches also available apart from the patent search. So one is patentability search that I have explained just some time, and then validity search, freedom to operate search, and state of the art search. These are the other searches available and or related to patent search. Novelty and patentability search. So as I stated, it is performed. It is commonly performed to identify the prior arts before the patent filing, and to determine whether your invention is novel. Also helps in drafting. It also helps in smooth patent process. That means you don't have any infringement, and you're not copying anyone's patent. That's why the process is very smooth. if you're very clear about your invention is new and novel. And the other search is freedom to operate, or we can also call it clearance search. This is mainly conducted by the manufacturing and major companies before commercializing their product. Because they have to check if they would like to commercialize their product in a particular jurisdiction or a region, they have to check whether related product is already available in that particular region. So to state that, or to confirm on that, we have to do the freedom to operate search. So it will also help to avoid infringement and also to check marketability. If there is no product is available, then you're free to market your product there. So what are the things will be focused on the search? The prior patents, and what are the valid claims and territories. Means prior patent in the sense for example, one patent can be found, but whether it is expanded in other jurisdictions or not, those things can be checked under territories. The next is validity search. Validity search is generally performed to validate your invention also for the opponent's patent. So during the opposition and pre and post patent opposition stages, you can perform the validity search and once after a patent, it can be done after a patent is issued. It will also help you to assess the strength of your patent. That means value of your particular patent. Whatever is granted to you. State of the art search. So it's kind of a broad search. Like you have to look into each and every details of this particular technology by doing the state of art search. So it will help you to identify what all the technologies already existing in the market, and who all the competitors, and what is the trends currently going on in that particular technology, and also what are the patents filed or pending in that particular specific area, in the sense in that particular technology area. So this search also majorly done by the companies and other people. So after the search, the next step was filing your patent application. So what are the filing procedures as per the Indian Patent Act? So for filing anything, there are some requirements. So these are the requirements for filing the patent application in India. So first is applicant details. So you are an applicant, then you have to provide your name, nationality, address, and entity type. If it is a company, then you have to provide the type of the company and type of applicants. So type of applicants in the sense who is going to file a patent, whether the natural person, that is individual, or a startup, or a small entity, or other than small entity, or educational institutions. So as I said, now under applicant types, educational institution is also added as per the recent amendment. So the fee is also reduced. Now the fees are in part with the individual or small entity or startup charges. And inventor details. So I have to provide the inventor details. Who all contributed to that particular invention can be considered as an inventor, and we need those details, their names, nationality, address, and gender for filing the patent application. And the foremost thing is whether you are going to file a provisional or complete application. So based on the type, you have to provide the description, claims, abstract, and drawings. Claims are not necessary in the complete in the provisional specification. It has to be submitted along with the complete specification. So these are the additional requirements based on the type of the applicant. For example, if you are a startup concern, then you have to submit the DPIIT certificate, that is called a startup recognition certificate, to prove you are the startup concern and also to claim fee benefits. And if you are a small entity, you have to submit MSME certificate. If you are educational institution, you have to submit the proof you are an educational institution and established by Act under central or state. if your invention related to any bio-related material, like if you are using the biological material in your invention, then you have to obtain the approval from NBA before patent filing. Also, it can be submitted after the patent filing, but before the grant. And source and origin of the biological material. So it is mandatory to include the source and origin of the biological material in your complete specification, from where you obtain the biological material for doing the research purpose or for completing your invention. If the biological material it's not available in public, that is something very new, then you have to deposit that material into biological depository, and you have to that has to be done before the filing of the patent application. These are the additional requirement based on the applicant type and has to be followed, so that only the system, the patent office can accept or recognize you as a startup or a small entity or an institution, and then accordingly the application will be processed further. So what all the applications are available with respect to patent protection? The first one is ordinary application, which is our general regular patent application, either provisional or complete. And the other thing is divisional application. Divisional application is if you are dividing something from your main application, and then you can file the divisional application. But divisional application has to be filed if there is any objection with respect to unity of your invention. It can be filed before the grant of the parent application. And then patent of addition. Patent of addition can be filed anytime before the lifetime. That means before 20 years, you can file your patent of addition. Any improvements, once the patent is granted, if you are doing further research and there is an improvement in your invention for whatever disclosed earlier, then you can file for patent of addition. That will be considered as a separate application, but the term will be similar. That means 20 years for your patent of addition. The next one is PCT international application. PCT is Patent Cooperative Treaty. So that has to be filed within 12 months from the priority date. I will be discussing about PCT in later slides. And PCT national phase application. For example, if you are a foreign company and if you would like to file the national phase application in India based on the PCT, then you have to file the application within 31 months from the priority date as per patent rules. And the other one is conventional application. There are two ways for filing the international application outside India. One is PCT route and one is conventional route. So what all the countries which is not part of PCT, you can go under convention route. But both the application has to be filed within 12 months from the priority date. Priority date in the sense from the first filing date, either it's a provisional or a complete, that first filing date can be considered as the priority date, and you have to file the application within 12 months from that date. So what is the purpose of provisional filing? So provisional application generally filed to obtain the priority date. As I mentioned earlier, if you have your invention or idea or concept, if you would like to get the priority for that, then you can file the provisional application with the basic details of your invention. Like you have to cover all the technical aspect of your particular invention, particular product or a process, and without describing in detail, and you can file a provisional application. And then within 12 months you have to file the complete specification. So in the complete specification, these all the subtitles or the major details to be presented, like title, what is the title of your invention, technical field, your invention under which field or under which category it falls, and what is the background of your invention. So under the background you have to explain about what is the prior art and what is the technical solution, like what is the problems in the prior art and what is the drawbacks, and whatever overcome in your invention, those detail has to be discussed under the background. And object of invention, what is the object of inventing this particular product or a process, and what is the purpose basically. and statement of invention and brief description of the drawing. If you're explaining your invention by way of drawing, those details has to be clearly provided under brief description with the reference numerals and with the explanation of each and every component of that particular drawings. And these detailed description also same, like whatever disclosed in the brief description, you can explain what the drawing states, and under detailed description you have to talk about the working and functionality and how it is connected. Those things can be explained in the detailed description along with examples or test reports or whatever the data available with you. And best method of performance, if you know this is the best method my invention can perform, and you can provide the details of those things. And claims plays a like major role in the complete specification, so it has to be clear and what is your claim of your invention, and accordingly you have to write the claims. And then abstract, a short summary of your invention. All these things are important in the complete specification, just to avoid any objection in the examination. These all these steps and timeline involved in Indian patent filing. So once you file the provisional patent application, the next step is filing the complete and the PCT application. So as I mentioned earlier, complete and PCT has to be filed within 12 months from the date of first filing. And there are other requirements like power of attorney and proof of right. Proof of right is kind of assignment from the inventors to the assignee, that is company or the institution, that has to be filed within 6 months from the date of filing. And what will happen after the complete filing? So your application will automatically be published after 18 months from the date of first filing. If you prefer like early publication, you can also request for an early publication so that it can be published as soon as the request is made. But the thing is, you have to request after the complete filing only. And then the other next step is requesting examination or expedited examination. So it has to be requested within 48 months. That means within 4 years from the first filing date. Generally, it is not required. You have to wait till 48 months, because as soon as you make a request, the application will be taken up and examination can be done and it can be processed for grant, or whatever the next process can be happen sooner if you file the request sooner. What will happen once the request is filed? The patent office will examine your application. Patent office, there are a lot of divisions based on your technology, and your invention will be assigned to that particular controller, and he or she will examine your application and they will issue the FER, that is first examination report. So you have to file a response within 6 months from the date of the FER. So after filing the response, the controller has to re-examine the response, like whatever explanation or the arguments you have submitted, the controller has to read through, and if everything is sufficient and there is no further objection, it will go for grant. If there is some more clarity he required, or he needs some more documents, then he will call for the hearing. We have to attend the hearing, and after the hearing, the written submission has to be filed within 15 days from the date of hearing, and then it will be granted. So from the publication till the date of grant, there is one gap. Okay, so any third party can file the pre-grant opposition before the grant of the application. So it is not necessary the person should be connected in your technology or in your space or domain. Any third person can file pre-grant opposition under certain grounds, like this invention is not novel, or there is no this invention not sufficiently disclosed, or whatever is the clause. There are a couple of clauses provided under section 25(1) of Indian Patent Act. Accordingly, you can file, any third party can file the pre-grant opposition, and it is necessary for the applicant to file a response within 3 months from the date of pre-grant opposition. If there is nothing, no opposition, then it will go for grant. So what will happen after the grant? So there is also possibility for the post-grant opposition, but here the case is only the interested person That means the company, the person, or any individual who is related to your particular field only can file the post-grant opposition. So the proceedings are totally different, and you have to file a response, and same like pre-grant opposition, there will be some evidence filings, and then you will get the hearing notice, and the matter will be disposed further to that post-grant opposition hearing. So these are the regular procedure. If there is no opposition, the process will be from filing till grant. And once it is granted, you have to pay the renewal fees. That is the regular process. So once the patent granted, what will happen next? The term of the patent is 20 years from the date of patent application. That is from the date of first filing, either provisional or complete. Okay, from the date only it will be started. And you have to pay the fees from 3rd year till 20th year. Okay, what are the rights as a patentee you are having? Like patent, as we discussed, the patent is a exclusive right to the person who is filing the patent application, the owner. So he can stop others making, using, or offering for sale of your particular product or a process. Even if it is a process, also you can stop others for doing that particular process. It can be a manufacturing process, it can be any research process, but if you're the patent owner, you can always stop them by doing so. So these are the rights you are having as a patentee. So patent renewal. So as I said, the term of the patent is 20 years. The renewal in the sense annuity fees. That means every year fees has to be paid from 3rd year onwards. So once you file the application, for example, today you are filing the application 2023. So once it is granted, you have to pay the fees from 2025. That means from 3rd year till 20th year, you have to pay the annuity fees. If you do not pay the fees, your application will be lapsed, like it will be seized for non-paying the annuity fees. So it is not it is not important you are getting the grant. It also important you have to maintain your application till the lifetime. So the other important stage after the patent grant is statement of working. So if you recall one of the criteria, that is industrial applicability. So this clause is connected with that section. Okay, so industrial applicability, as I said, it has to be, your invention has to be worked in an industry. So once the patent is granted, you have to submit the working statement. Like you have to submit the statement saying my invention is working in an industry and these are the details. Okay, that working statement has to be furnished every financial year, starting from the financial year immediately commencing after your grant. So if your patent is granted, then you have to file the working statement for the financial year immediately coming after your grant. So the timeline is September 30 of every year. You have to submit the working statement. So either it is working or not, you have to submit the statement. If it is not working, you can just say it is not working and what are the steps you are taking for working for that particular invention. Like you are coordinating with the investor, or if you are coordinating with the manufacturer, or if you are looking for the license, whatever is the scenario, you have to submit those details to the patent office. If it is working, then you have to provide these details, whether manufacturing is happened in India and what is the approximate revenue from the particular patented product or a process, and whether it is imported from other countries, or and what is the revenue from the importing, and whether you have licensed or sub-licensed to somebody. You can either give an exclusive license, or you can give a sub-license to multiple people for doing, like, for working your invention. Those details has to be filed under Form 27 every financial year. That is the mandatory requirement to be compiled with every patentee. compulsory license. This is something connected with the working of patents. What if you got the patent grant, but you're not able to work for certain reasons, like there are some financial concerns or whatever it is. Then the patent, if some third party is interested in your invention, they can always come and ask you about license. So what if you're not giving the license? So that person can approach the patent office for compulsory licensing. Okay, so the patent office will check whether you are working on the patent or not. If you are not working, then they have all the rights to give the grant license to a third person to work on your invention under certain conditions. So they can give the rights. That person has to work on your invention, and they also need to submit the working statement. Whether that means the licensee also need to submit the working statement stating whether the invention, whatever licensed to them, is working or not. Based on that, it will be decided whether the license can be extended or it can be cancelled based on the submission of the working statement. So those are related to Indian patents, like you're doing the search, you're filing the application, and what are the steps, and it is granted, and after the grant you have to pay the annuity fees, and the statement of working has to be done every year once the patent is granted. And the next subject is related to international patent filing and timelines. So as I explained earlier, there are two routes for filing the patent internationally. One is patent cooperation TT and the other one is conventional application under Paris Convention route. So PCT has 157 contracting states, like 150 contracting states has signed agreement with PCT. So what are the countries available under PCT? You can file one single application, and then later on you can designate individually under the PCT member countries, whatever the countries so you are interested to enter. For example, so if you are filing the PCT application today, and within 30 months, the 30 months from the date of first filing, that is your priority date. From the date of priority date, within 30 months, you can file the application in other countries. Why we are choosing PCT means PCT will give you timeline than conventional application. If you are selecting conventional route, you have to file the application in individual countries within 12 months. However, PCT will give you 30 months to decide what all the countries you are interested. So that is the major advantage by choosing PCT route. And PCT it's a forum or a platform for blocking or registering your international application. It will not give you grant. The grant will be given by the individual countries after the national fees filing of each country. So what are the other advantages of filing the PCT application? One is international prior art search. So once you file the PCT application, you also need to select the searching authority. There are a couple of searching authority available as per Indian applicant. So you can select the searching authority, and they will perform the search, and also they will give you the written opinion. So if for example, if your claims are not well drafted, and there is some modification required, and there is some inventiveness problem based on the citation, they will also cite the prior arts, and they will also highlight based on these prior arts your invention is not novel or inventive. So if you think, if you amend the claims, or if you do some modification to that, you could able to overcome these objections. You can always amend your claims during the international stage. That means you can amend the PCT claims. So those amendments can be reflected in designated offices. Like it will be kind of single amendment, but later on while you are entering the individual countries, your application will be entered with the amended version of claims. So there is no need to amend the claims again. That is one add-on here under PCT filing. That will be called Chapter 1 amendments under Article 19. You can also amend the specification under Chapter 2 under Article 34. if you'd like to make any amendments to the drawings or claims or specification. But Article 19 only you can amend the claims. Okay. So, for example, if you decide I don't want to amend any claims, but I just want to give a response to the searching authority that my invention is novel based on these criteria. Okay. So, what can you do? You can file an informal response to the International Bureau stating based on these points, my invention is novel and new. So that informal response can be filed before filing the national application in other countries. Okay, these are the advantages for filing the PCT application. The next thing is national fees. So as I said, once you file the PCT application, it is necessary for you to select the countries under which you would like to file the national fees application. Under one, it is not required you have to file all 157 countries. In all 157 countries, you can select your interested countries. For example, if you decide I want only 10 countries, then you can select those countries and you can enter into those countries under PCT. Like you can, based on the PCT, you can file the national fees application in the individual countries. So the timeline differs from country to country. Few countries having 30 months and few has 31 months. Okay, there are two countries like I think Tanzania and Ludhiana, I think so. So those two countries having 20 or 21 months from the priority date. So within that months, like within the 20 months, you have to file the application in those two countries. So these are the timelines for filing the nation fees application in individual countries. This is the general timeline for PCT system, like how can you proceed, what are the timelines, like you're filing the application in your national office, that is an Indian Patent Office, and within 12 months you are filing your international application. Then the ISR, that is International Search Report, will be issued, then it will be published and you can go for the steps, that is demand. As I said, you can file the demand to amend the specification under this, and then you can go with the national fees applications at the end of 30 months to the individual countries. The grants will be decided based on the requirements and regulations of individual country. Each country, your application has to be has to pass all the procedural things. For example, publication, examination, responses, annuities in each countries. So it will be treated as an individual or a regular application after entering the national fees, and the grant will be decided accordingly. So this is the PCT system. So that's it. I'm just concluding my session. If you have any doubts, you can ask.
Thanks for an excellent section, ma'am. We hope our participants will take lot of information related to patent registration and procedures. Participants are kindly requested to post your queries in either chat box or unmute yourself for doubt clarification.
I think Mr. Ranjit Babu asked website URL for patent registration. Sir, you're asking about Indian. Yeah, my colleague Danya responded. It's ipindia.nac.in. So here, sir, if you're filing the patent application on your own as an applicant, you can nowadays as an applicant you can file the application physically. If you're doing it in online, you should have digital certificate for signing your application. for submitting your application digitally. For licensing, the other query is how do I go about licensing my patent? So like either you can look for the how to say, you can look for the companies or any manufacturers doing the product related to your patents, and you can approach them for the licensing. Or if any third party coming to you for the license, and then you have to prepare a license agreement, and it can be mutually agreed, and it has to be executed for a certain period. You have to define the terms and conditions in the license agreement.
Ma'am,
Yes.
how much will be the annuity fees till 20 years?
So annuity fees also with respect to the applicant. For example, if you are asking as an individual, there are only two category of fees. One is for applicants, individual, that is individual, small entity, startup, and institutions. So for 3 to 6 years, you have to pay 800 per year. Okay, and for 7 to 10 years, you have to pay 4,000, and it will keep on increasing slightly. So every 4 years, there is an increase in the fees.
Thank you, ma'am.
Um, I think Madam Gomati asked, can we register sponsored project implementation as a patent? Ma'am, if you are doing like if you are doing the project like if you are doing the research, but the project is funded by some third party, then you have to decide who will be the applicant, whether you or the company. If the company decides they only can be an applicant, then you can list your name as an inventor and you can file the patent. Dr. Anup Prasad. So you have filed the patent application and it is pending for 2 years now. So like as I mentioned, patent application will be automatically published after 18 months. Okay, so you have to request examination. Then only your application will be examined and you will get the first office action, and you have to file a response to that. Then your application will be granted or decided. Thank you, sir.
Ma'am, once patent has granted, kindly give suggestion regarding commercialization, ma'am.
Okay. Yeah, once it is granted, as I said, you have to keep your patent alive. So once it is alive, only you can do the, like you can sell, or you can even sell your patent to any third party or the companies, or you can give the license for commercial. For example, if you're got the patent and you are from the institution, of course you don't have any manufacturing and those kind of setups immediately, no. So you can look for some licensing. You can collaborate with the companies. Generally institutions used to collaborate with the companies, and they will do the even technology transfer. You can do the technology transfer, and by that you can commercialize your patent.
Okay, ma'am. Thank you.
Yeah.
Ma'am, one more question in chat box, ma'am.
Yes. So if you are saying your patent is not working for so many years, like you can say for 3-4 years. If you are saying more than 5-6 years, like there will not be any issues unless the patent office come back and ask, or any third person raise the queries. Okay, but as per the act, you have to provide some details. You have to put your ideas to make that invention workable. like you have to license or you have to do manufacturing, whatever is applicable, you have to do that. But as of now, there is no strict, how to say, process by the patent office for checking these things. Yes, sir. If your granted is, if your patent is granted during fifth year, you have to pay the outstanding annuity fees from the third year onwards. Ma'am, Kapila scheme is about recently came up no for patent filing. You can approach them and check for patent filing if your institution is referring that. How many times we will get the hearings? Generally, we used to get only one hearing. Rarely, second hearing will be issued if the matter is not concluded in the first hearing. We have not seen any matters having more than 2 hearings.
Participants, any more questions? Okay, ma'am. Thanks for your valuable inputs and the clarification regarding the participants' query, ma'am. Participants, kindly feedback link was posted in the chat box. You may fill the form. This link will activate for only 20 minutes. Certificate will be dispatched to the participants only after completing this form. Certificates will be sent to the participants within 2 working days. Now I call upon Mrs. Subham, ma'am, Assistant Professor Senior Grade in Department of Civil Engineering, to deliver the vote of thanks.
Thank you, ma'am. On behalf of Department of Civil Engineering and Ramco Institute of Technology, first of all, I extend my sincere thanks to the Almighty for making today's workshop a resounding success. I extend my heartfelt thanks to our resource person, Mrs. Suganya Jayavelu, ma'am, pattern analyst, Putran Associates, Chennai, who spared her time to grace the occasion. Today, we had a fruitful opportunity to hear your thoughts regarding an overview of patents and procedures for the protection, and this will surely be going to encourage all of us in the future processes. Thank you, ma'am. I extend my thanks to the management, principal, vice principal, and HOD for encouraging and supporting us to conduct the workshop. I thank the faculty coordinators and the technical members who worked behind the screen for their solid support to conduct this workshop in a well-defined manner. Last but not least, a big thanks to all the participants who have attended this workshop and got clarified regarding the doubts. We would like to continue your valuable presence during all the upcoming events. Thank you, one and all. Thank you again.
Thank you, ma'am. Thank you so much for the
Thank you, ma'am.
opportunity.
Thank you, ma'am. Thank you. Participants, kindly fill the feedback form. Your certificates will reach you within a couple of days. Thank you all.